to the Elder Law Out Loud podcast. I'm Karla here with the CEO of Family First Firm, Geoff Hoatson, Florida's largest elder law firm. And today we are talking about what happens after you receive a life-changing diagnosis, because a lot of our clients end up coming to us after they have received bad news, unfortunately, whether that be a cognitive diagnosis, which we'll talk about in detail, but even just, life-threatening diseases, chronic illnesses. There are some tools that we have in our toolbox that can help sort of plan out the future.
That's right.
When so much is unknown when it comes to health issues. Yeah. So when clients get that diagnosis, they get a call from their doctor or they're hospitalized and the doctor comes in with a bad news chart. What do you think after, grieving that is one of the first things that they should be doing?
Generally speaking, a diagnosis of this magnitude, whether it's a cognitive or potential cognitive impairment, we had a client in here last week who came in to get her estate planning in order she would make everything easy for her daughter and her grandchildren because she was diagnosed with stage 4 cancer with, mets all over her body. But, generally the first legal thing that I think people need to consider is really advanced directives. That's, I think, the number one thing because we don't know what the future holds. Now, obviously, if you've been diagnosed with, some sort of cognitive impairment, whether it be dementia or Alzheimer's or some variation thereof, we know that at some point you will not be able to make decisions for yourself. You won't know what's going on, unfortunately. And that's tragic and it's sad, but we know that that is the ultimate result of those diseases. They are degenerative. They don't get better for the most part. You could just delay them at best. So in those cases, we know that if you're not going to be able to make decisions for yourself, we've talked about on this podcast a lot that there are only two ways that somebody else can make legal decisions for you. You either give them that right through those advanced directives, or they take that right through that guardianship process, that involves courts. It's very expensive, time consuming, onerous, judicial oversight on basically everything you'd want to do for your loved one.
Indeed.
Yeah, it's terrible. It's terrible. And it lasts as long as your loved one is alive. So the first, most important thing I think is to get those advanced directives in order, the power of attorney so that someone can make legal and financial decisions for you, the designation of healthcare surrogate so those people can make medical decisions for you, putting together a living, which as a reminder to everybody is instructions as to whether or not you want to remain on artificial life support. Some people have, very strong feelings about which way most people do, honestly. This or that. It's not like, well, I'm kind of in the middle. I'm not really sure. It's either "Hey, I don't want to be on life support or yes, do keep me on because I believe in miracles. But in those situations, you want to be able to give those instructions to your loved ones and the people who are going to make those decisions for you. And because we know at some point you won't be able to make those decisions and you have to sign those documents when you do know what's going on, those, in my opinion, are the first most important things to get in place.
Okay. Some healthcare systems will bring documents like that into the room. Are those going to be as good as what you can create, with a law firm?
Yeah, definitely not. They're very basic documents. They generally don't contain the verbiage that you would want. They're honestly, they're more to protect the hospital than they are to protect you.
Interesting.
In a lot of cases, the hospital systems want you to sign that living will, discontinuing life support and everything. They don't want to be caught in the, well, we don't know what's going to happen or we have to wait for someone else to make a decision. They want you to just say, yep, discontinue me from life support. Then they can hold this up to your family and say, look, this is what they wanted.
You're making those decisions under pressure
Under pressure
you're in
and
the
very
hospital.
emotional. You just received some very terrible news and now you're being presented with these documents about what you want to have happen. I'm not saying that I'm not trying to, disparage the hospital systems or anything like that. But at the end of the day, every institution is really looking out for themselves, making sure that, there's no conflict or unnecessary issues. I will say in lots of cases, people who have, who are on life support and whatnot, they may not have a insurance that's paying for that. And so the hospital system has you in a bed, they provide you medical care, and they're not being compensated. And that can be a major concern for those organizations.
Especially if it goes on for a long time.
Exactly.
Yeah. So you want to make these decisions when you have a clear mind. You've maybe had a couple days out from getting this news, and you want to do it with a reputable firm.
Yeah, absolutely. I mean, have conversations with your family about it. I mean, it's not just something that you should make under pressure by yourself. I truly think the best decisions come from involving the people you care about, and at least if you aren't looking for their opinion on it, at least you can let them know that you've decided and made that decision, like you say, with a clear mind, letting them know, having those conversations about why you're making the decisions that you're making. Then when you come in here or any other
Yeah.
reputable law firm to get those documents in place, the likelihood of family members challenging or anything like that is extremely low.
Yeah. Okay, so advanced directives, that's priority number one. Of those advanced directives, would you say any of them are more important than the other?
I think the first three that I mentioned, really, that durable power of attorney, designation of healthcare surrogate, and living will are probably the biggest three, the most important. I think it's important that you did mention having a reputable firm put these documents together. I met with a client family yesterday on a Medicaid matter. And they're like, well, we have power of attorney. I said, great, let me take a look at it. I looked through the power of attorney and I said, oh, geez, is this where you're not, like, do they not focus on this area of law? And they're like, oh, no, they definitely do. This power of attorney was, as we so often see, not in compliance with what is now a 15-year-old statute change. They didn't have any place for initials in the document, and this is someone who purportedly focuses on this area of law. Now, obviously, I don't know whether that's true or not, and ultimately, I talked with this family about some other strategies we could use to maybe get around this, but ultimately, you know, th- it's
The power of attorney
it
wasn't
wasn't.
adequate.
It wasn't. And, I had, unfortunately, to tell the family this, and they had this done back in April of this year. So it wasn't like this goes way back or anything like that. It was 2 months ago.
It just paid for it.
Yeah. Yeah. And
Wow.
it's not good. Yeah.
Okay.
So,
And is there capacity to create a new one?
there is. So in this case, that she could update. Now, we're talking about Medicaid and some of the Medicaid strategies that we would utilize. Would, I think, make some of those issues a non-issue, if you will, because we'd probably move most of those assets out of that applicant's name in a way that Medicaid permits. And the issue with gifting or changing beneficiary designations, well, that's probably not going to be a big issue for this particular family. Um, but if we don't do that, yeah, they'd really have some problems.
Yeah, and power of attorney, not just for the purposes of Medicaid qualification. Down the line, we just don't know what will
Yeah,
happen. It'd be nice to have a document that will work when you need it.
exactly.
Okay, so I think a lot of people automatically jump to, I need to write a will. I need to get my last will and testament set up so that people know where my stuff is going to go.
Yeah.
Would you say that that's high priority in a situation like this?
I think definitely. I mean, when it's about getting your wishes in place and in writing, it is important to start having those discussions. Is the will the right tool? Maybe not. As we know, and listeners of this podcast know, wills go through probate. They are your ticket to probate. They are at the core. They are nothing more than a set of instructions to a probate judge. They have no meaning outside of that probate process. If somebody, like we regularly have, comes into our office, brings the will, says, "Hey, this will says everything goes to me. I'm trying to sell my mom's house," and the realtor says I need probate. I don't understand why. Well, it's because wills go through probate. It doesn't mean anything when it isn't there. Um, that's what, you know, kind of interesting. With a power of attorney can't sign a will for you, but they could create a trust. So sometimes we have people who get a will in place, and then maybe later on their power of attorney says, geez, it's going to leave a big mess for us. We want to put a trust in place. And they can do that if they have a good power of attorney. I think you're overpaying if you do that because you pay for will and then you pay for a trust. In a lot of cases, it might make sense to just get a trust in place first. But yeah, I mean, thinking about your estate plan, it definitely is an important thing when you're faced with these diagnoses, because if your capacity is going to disappear at some point, well, it's too late to do that stuff. So, I think it makes sense to kind of get all of these legal issues, I guess, resolved in advance while you still know what's going on and you can make your wishes heard and put down in your documents.
Yeah. In the case of cognitive diagnoses and some neurological other disorders, like Parkinson's, you've got a little bit of a runway, so to speak, most cases, where you can do this planning for not only your estate, taking care of your family, avoiding probate, but also for long-term care. And you can do that at the same
Yeah.
time. So talk about those tools and that sort of comprehensive planning.
Yeah. So we have pre-planning tools that we use to get people eligible for benefits for long-term care, whether it's VA benefits or Medicaid to pay for long-term care. As a reminder, Medicare does not pay for long-term care. So the only ways you pay for long-term care
It
is
should be renamed.
yeah, I know. Like,
Meta not care.
yeah, not kidding. Well, it provides all the medical care. It just doesn't provide long-term care,
Okay.
But the only 3 days that people pay for long-term care are going to be self-pay, Medicaid, or a long-term care insurance policy. That's it. There are no other benefits that will pay for that. So, um, some of the pre-planning tools that we use are these irrevocable or irrevocable trusts. And, that those can be great tools. Now, it really depends whether or not that's the right tool for somebody who's, you know, had a diagnosis. Um, it depends really on where they are. Because if you have someone who's very early in the process and there's a lot of opportunity to delay it, that can definitely be a good tool. If we're kind of, deeper into a diagnosis, maybe there's, significant cognitive impairment, that may not be the right tool. We may want to focus maybe instead on like crisis planning, which is where we're utilizing loopholes in Medicaid or VA code in order to be able to protect some assets and get them eligible for benefits. Obviously, the pre-planning trust work is better across the board, but those tend to carry look back periods with them 3 5 years, and so if you don't have that amount of time, that may not be a tool that you can use. If and like I said, it has to kind of pass the smell test on that. We've definitely, you know, worked with families and they've had assets in these trusts for less than 5 years and they've still been able to get Medicaid. Um, and there's a kind of a long discussion about how that works, but the gist of it is generally you're expecting those timelines, the 3 years for VA, the 5 years for Medicaid. And if you don't have that runway, those tools may not be as effective.
Okay. And not for nothing, a lot of people don't like those tools because they want to have direct access
Yeah.
to their
Yeah.
assets as
So
long as possible.
when you use those trusts, you cannot be the trustee. You can't be the person who's managing it. So if you move all of your stuff in there, you've basically given up control of a lot of your stuff. Now, if you've received some life altering diagnosis, that may not be your primary concern. It's like everyone says, you have all these problems until you have a health problem. Then you just have one problem. Nothing else really matters. I had a crazy, as a personal anecdote there, I had a crazy sinus infection that I've never had a infection before in my life.
Not to compare a sinus infection to like
Not at all. But no, no comparison. But real significant was creating this insane pain on the side of my face,
oh yeah.
in my teeth,
Mm-hmm.
in my lower jaw. It was going up behind my eye, like up the side of my head. It was wild.
Speaking my language because it happens to me every season.
Oh, okay, cool. I mean, not cool.
No, it's
You know what I'm talking about. That was the first time I'd ever experienced this, and it was debilitating. And it was amazing how nothing else really mattered until I got that under control. So we talk about having all these other issues and problems, and there's a lot going on in my life. But for that week,
yeah.
that was my problem.
Was that when you thought you were having a dental issue and it was actually the sinus?
Yes, yeah. It was the wildest thing because I guess the pressure in my sinuses actually were like
Pushes down.
pushing or pulling,
Yeah.
whatever. To the point that like my teeth were shifting in my mouth.
Uh-huh.
And I was like, are my teeth gonna fall out? And then after the antibiotics cleared it all up, everything was back to normal. But yeah, it was
It is
really wild.
crazy how it impacts everything.
Yeah. So that was my first run at that. So at least now I'll know for the future. But
Be
yeah.
in the daily Claritin train with me
No kidding. It was
moving
something.
forward. Okay, so once you've got sort of your directions in place, either through a will or trust, the trust is going to protect a property, but a will doesn't necessarily protect your home. If your home is your main asset, for most people it is, what are some of the other ways that you can, avoid probate for your family and protect what you've, invested in?
Generally, if we're not using a trust, we're using the ladybird deed. Those are really the two main tools. Occasionally, people will quit claim property, basically just gifting it.
Not great.
Generally, no.
Yeah.
There's major tax implications to doing that if the property's been owned for a while. So if, we do have situations, I will admit, where, the person who's thinking about gifting the property says, oh, I bought it last year. I'm like, okay, well, obviously, we don't know when you're going to pass away, when your child's going to sell that property. But it may not be as bad as if you purchased this property 30 years ago, and now you're looking at probably a, mid 5 figure, maybe up to 6 figure tax burden when your child goes to sell this property. So, um, we do tend to use ladybird deeds. Those are basically like beneficiary designations on a deed. So a beneficiary designation, like if the most common example I think people know is like if you have a life insurance policy and you pass away, that policy goes to the beneficiary who you've named on the policy. It doesn't go through probate, it goes directly to that person. You can do that with bank accounts, investment accounts, retirement accounts, just about any financial institution you can name beneficiaries on. However, the only way to do that with a piece of real property in Florida is through a ladybird deed, and it's basically a beneficiary deed. I won't take you down the rabbit hole of how it actually works.
I
It
would like to know how it actually
Yeah,
works.
okay.
Yeah.
Well, now here we go.
Sorry.
No, it's okay. So
I try to explain it in
yeah,
layman's terms, and I say it passes the property to the next person upon the death of the original owner.
which is true. But the other states actually have true beneficiary deeds. We do not. This is a I don't know a phrase. It's like an enhancement. Well, I guess technically it is. It's called an enhanced life estate deed. Is the actual legal term for it. Ladybird deed is just like a colloquialism. So basically, the way so I'll start by describing what a life estate deed is. So, a life estate deed gives somebody that we call the life tenant the ability to live there for the rest of their life. And then when they pass away, there are the remainder, the people who get the remainder after you've passed away. So you have kind of like the during this person's life, they've got the property, and then after they pass away, it goes to these other people. That works very well in a lot of cases. The downside of that is that remainder gift is considered a gift for the purpose of things like Medicaid or VA benefits or things like that. You've now intentionally divested yourself of some portion of that property. There's actually the IRS has a calculator to determine what if a property is worth $100,000 and you've signed a remainder, I'm sorry, a life estate deed. They will, okay, if you're this age, here's how much is your value as the life tenant, and here's how much is the remainderman's value as the remainderman. So they there actually is some value that's gifted, and that obviously counts as like a transfer for Medicaid purposes. A life estate deed is I'm sorry, a ladybird deed, an enhanced life estate deed basically is that same thing, except it says for the life tenant, I still retain all the rights to do
100%.
whatever I want with it. So I can give it away, I can sell it, I can mortgage it, I can transfer, I can burn the place down. Whatever I want to do, I can do with it. And because I retain all those rights and abilities, those remaindermen don't really have any value because, well, we don't know if you're going to own that property when you pass away. With a true life estate deed, in fact, if you wanted to sell that property, you have to have the remaindermen come in and
Sign
sign. Yeah, they have to be part of that transaction. Where with these enhanced life estate deed, ladybird deed, you don't have to do that.
So we have both in Florida?
Yeah,
Yeah,
absolutely.
absolutely.
Okay, so when you're looking up a property on the property appraiser's website, that's like what you need to look for is whether it says enhanced or not.
So believe it or not, it won't say that on the property appraiser website. You'll have to look at the
Or in the
deed.
clerk, I
Yeah,
guess.
and so you go to the deed, and that could be at the comptroller's office or the clerk's office. Each county has them differently where the official records are. But when you go to the deed, sometimes it won't even say that language. Truly, you just have to read the deed to see if
Which is something we all know how to
yeah,
do.
exactly. So there's so many different forms for this. There's not like a standard way that it's supposed to look. So, for us lawyers, we go in and we just read through and look and see if we have those retained rights. Because sometimes it'll just say quitclaim deed, sometimes it'll say enhanced life estate deed or ladybird deed or warranty deed or special warranty deed up on top. You can't trust the title of the deed because that really is immaterial for determining whether or not this thing is a ladybird deed.
Wow. So you could mistakenly think that you're getting a ladybird deed and just have the regular life estate deed.
Yeah.
And then that would not only not protect you for Medicaid purposes, but it would maybe create issues during probate.
Yeah, but there won't really be probate with that because the remaindermen just get it by operation of
Okay.
law because they are beneficiaries on it. But if you wanted to sell the house or something like that, or get a mortgage or a reverse mortgage or a home equity line of credit, those would be problems because all the remaindermen would have to agree and sign off on any of those things.
Okay.
And if you've got a child who's squirrely or whatever, they can absolutely prevent you from being able to do any of those things.
When the original owner passes away, does the remaindermen, the percentages that they had during the person's lifetime, does that impact their step up in basis or anything like
You still get a full step up.
Okay.
Okay.
Yeah. It operates from a practical perspective. If somebody signed a regular life estate deed and then never, wanted to sell the property or anything, and they didn't need Medicaid, hypothetically, it would operate the exact same way as an enhanced life estate deed would. But there's just a lot of downsides associated with it. A lot of ways that things can go wrong. And like I tell people, we don't know what the future holds for anybody. And you don't know if you're going to need access to the equity in that house or whatever at some point down the line. And so there's no benefit, in my opinion, to using a regular life estate deed over a ladybird deed. So, in our office, basically across the board, we're
that's
using
all we offer, really?
for the most part.
Yeah.
Yeah. Um, we'll hear from clients who say, I already added my kids to the house. Usually they
Oh, I
mean
hate
they
that.
put them
Yeah.
on as a quick claim deed.
Yeah.
Talk about the downsides to that.
Yeah, so that's where you can get into the big tax issues for those children. That's what we were talking about previously when we were talking about tax basis and getting that step up. This gets a little, I don't really like to draw and illustrate when I talk about this with clients, but I'll do my best to describe it in layman terms. I think the most easy thing for people to think of is if you like bought a stock. Let's say you buy a stock for $100 and then you hang on to it. You bought Apple back in the day and it went up to $400 and you decided to sell it. And so you have $300 of profit. Well, the $100 you paid for it is considered your tax basis. Now, if you've held it for over a year when it went up to $400, then you would have to pay long-term capital gains on that $300. Now, right now, that's 15% taxes, unless you're making like a lot more income, they could push it up to 20%. But that 15% that you would pay on that $300 is, what is that, $45, I guess. In that,
Don't look at me.
I went to law school, not math school, but I still think that's
I'm
I think
I'm
that's
a
accurate.
journalist
Yeah,
by,
yeah.
by trade. We don't do math.
I'm pretty sure that's accurate. So, so the example though that we're talking about here in the house is, let's add some zeros to that and say you purchased the home for $100,000 and now it's worth $400,000. If you just add your kids to the deed, when they go to sell that place, and it could be worth 5 or 600 by the time you pass away, they're going to take your original tax basis, which is that $100,000. And so let's say they now sell it for. I'm just going to use the same numbers here. They're going to sell it for $300,000 or $400,000. I'm sorry. So there's going to be $300,000 of profit there. They're going to pay $45,000 in capital gains tax to the IRS. Now, by contrast, if we were to use a trust or a ladybird deed or something of that nature, um, the children, when they receive the property after you pass away, their tax basis jumps up to the fair market value at the date of death. So if we use those same numbers, it goes from 100 up to 400. And now if the children decide to turn around and sell the property at that point, there's no gain. And so they are treated as having paid $400,000 for it. They sell it for $400,000, so there's no tax associated with it. So that's where you get people who are like, "Oh, I don't want my kids to have to go through probate." Probate might cost you $4,000. And if it's just a home, the $4,000 and maybe 3 to 4, maybe 5 months, depending on the county, to get all this done and transferred over to your children. So you saved $4,000 in a few months, and instead you subjected them to a $45,000 tax bill.
Yeah.
It's people just don't understand the tax code. It's very complicated and very difficult for most people to understand. So, that's where when people come and say, "Oh, I need to add my kid to the deed," I'm always like, "Well, time out. Let's just talk about what your goals are, what's going on in your life. Adding your children to the deed could also disqualify you from Medicaid."
That was the next question I was going to have. So when you add your children to the deed, even though, in your mind, it's probably not a gift, it's a probate avoidance tool, is what you think it is. It looks like a gift to Medicaid and a pretty expensive one.
That's right.
Yeah.
They say, "Hey, I mean." So the way Medicaid looks at it is it's about, I'm just going to round and say for every $10,000 of value that you gift away, you have a month of a penalty where Medicaid doesn't cover you. So if you have a $400,000 house, you added your child to the house, the presumption is going to be your child owns half that home. So now we're talking 20 months because half of 400,000 is 200,000 and 200,000 divided by 10,000 is 20. So 20 months of ineligibility for Medicaid. unless you have that child deed back
Mhm.
that then we use a ladybird
Whoopsie.
deed or something else. Yeah. And fortunately Medicaid does allow you to do that. They call it curing the gift. And so, when people well-meaningly do this but don't understand the issues, we can certainly reverse it if the children are on board with it, and that's a big piece of this. But if the children are on board, we can reverse it, move that property back, and then do like a ladybird deed or something else to move the property in a way that Medicaid permits. That will also give them the step up in tax basis, not create a penalty period. So there are a lot of ways you can do this the right way if you're working with someone who understands what to do.
Yeah. I know it's kind of outside of our scope here at the firm, but can you talk a little bit about the life insurance policies or long-term care insurance policies, I should say, not life insurance, but the long-term care insurance policies? Um, are you eligible to get any of those after you receive a diagnosis in most cases?
Generally, no.
No. So if you had one previously, what are some of the pros and cons of having those policies and carrying them out?
So if you've been paying for it, you get to a point where, care is likely in your future, that's wonderful. That's truly why you paid for the property. And the property, I'm sorry, the policy. And that's what that's about. I think the challenge that you run into is a lot of them have elimination periods. They might be 60 or 90 days. So you're receiving care, but they're not paying you yet. You'll have to pay on your own for 2 to 3 months of care, and then the policies will start paying. They generally have either monthly, daily, or annual limits associated with them. Sometimes that's problematic. You c you could be looking at policies that limit your, monthly benefits to 4,500, $5,000 a month. We see those regularly. Maybe has a lifetime cap of 250, $300,000. I mean, again, that's not nothing.
Yeah.
I mean, that's a substantial amount of money, but it's not enough to cover a nursing home. It's probably not enough to cover the in-home care that you're going to need. So in those situations, they can, I'll say, do not do more damage, but it would be damage, but they don't help. If you're in a nursing home and you're handed a bill for $15,000 a month, getting $5,000 from a insurance company isn't really helpful because you're still looking at an extra $120,000 a year that you have to pay out of pocket. So, sometimes in these situations, we are letting policies go even. Um,
Because can you have the policy and Medicaid at the same
you
time?
can, depending. You can. It depends on what type of policy is, whether or not it makes sense to keep. So there's two major types of these insurance policies. There's indemnity and reimbursement. Indemnity, they pay directly to the provider. Reimbursement, you pay out of pocket, you submit a receipt, they issue you a check. What sometimes we'll do is the insurance companies will oftentimes, if we have someone who's on Medicaid, we'll use this, let's say, in like either an in-home, I mean, it could be assisted living, although not as frequently, but also a nursing facility where there are going to be extra payments beyond what Medicaid pays. So if you're in a nursing home, you have to pay your monthly income as your patient liability, minus the $160. So that's an example where you may have somebody who has a long-term care insurance policy pay, let's say, $2,500 to the facility. The spouse will submit that for reimbursement, and they will cut a check back to the spouse for the $2,500. So now, essentially, you're getting the nursing home for free, by virtue of the fact that you have this long-term care insurance policy. So that can be useful. In home, Medicaid might be providing 40 hours a week for you, but you need an extra 20. So you pay that out of pocket. You submit to the insurance company and they reimburse. Again, normally it's the spouse. Makes the most sense. If there's not a spouse to reimburse, oftentimes it doesn't make sense to keep it because if the money comes back to the Medicaid applicant,
Is that seen as
as
income?
soon as income, it's a problem. And now it's just funneling into a qualified income trust or something of that nature, which, doesn't really do any good for anybody unless you need even more care and you're kind of like doing this whole, paying it out,
Yeah.
submitting and
Like
round and round we
whack-a-mole,
go.
that,
Yeah.
yeah.
So, but when there's spouses involved, oftentimes, the insurance companies will write those checks to the spouses. And because we're in Florida and Florida has that name on the check rule, where whoever's name is on the check that comes in, they assume that it's that person's income.
Mhm.
So if the insurance company will write that check to the spouse, now it's the spouse's income. We know the spouse's income doesn't affect Medicaid eligibility for the applicant, and now they can get those funds in. So there can be circumstances where long-term care insurance policies work well with Medicaid. They just tend to be the exception.
I think to close us out, any advice to the loved ones, the caregivers, the adult children, of people after they receive a diagnosis, and everybody's head is spinning. Um, any advice on how to sort of steer the conversations and right the ship on the correct path?
Yeah, I mean, I think, one of the first things, it's not legally related actually, but I think getting into or joining a support group
Mm.
specific to that diagnosis is incredibly helpful. Just to kind of be there with people who are going through it, to understand better what to expect, to have access to resources to help you emotionally, potentially financially. I know that we do a lot of speaking to these support groups, and a lot of people in those groups just didn't know that Medicaid's a possibility. But by virtue of the fact that they're in a group now, they have just exposure to more information, more options. Um, but as far as having the conversation around the legal stuff, I mean, truly, a diagnosis is, I think, the easiest time to have that conversation because now there is clarity around what is going to happen, what is coming. I think once everybody understands, call it the rules of the game, it's easier to say, okay, well, now we need to plan for this. We know what's coming down the pipeline. And so, it's basically irresponsible to not have a plan in place. I think when we're younger, we're invulnerable, we're fearless, and nothing's ever going to happen to us until we're 120 years old. And so it's easy to put that stuff off. It's easy to avoid those conversations. When you get to a point where, hey, now there's some finality around what's going to happen, and there's so much, call it clarity, but truly just
The clock is ticking.
yeah,
Yeah.
yeah. So
You've got a deadline that you don't know what it is.
So I think it actually makes that conversation easier and less awkward because everybody understands what's happening.
Yeah. All right. Well, it's a tough topic, but I think a lot of really good advice out of this episode. So thank you so much. And thank you for watching. We will see you next time.